Hello, everybody. My name is David Socol de la Ossa, and I'm a professor at Hitotsubashi University in Tokyo in the Legal Innovation Department in the Graduate School of Law. Today, we will be presenting our paper, Artificial Intelligence at the Bench, Legal and Ethical Challenges of Informing or Misinforming Judicial Decision-Making through Generative AI. This is my colleague and good friend, Nydia Remolina, and professor at Singapore Management University. Next slide, please. Fantastic. So as I mentioned, today we will be discussing the impact and integration of generative artificial intelligence into judicial decision making. In essence, what we will be talking about today is how do we harness the power of artificial intelligence to enhance our courtroom system, and how do we make sure that this integration doesn't exacerbate the risks of artificial intelligence integration into any industry, and particularly the legal industry, given heightened scrutiny and the potential to affect the rights of individuals within the court and the judicial system. We have seen a tremendous rise of generative AI throughout the last couple of years. The last several decades have seen an inertia of increase in the use of artificial intelligence generally, but with new developments in generative artificial intelligence, given the growth in computing power, data availability, and development of deep learning algorithms, as well as the democratization of these services through open platforms, have massively increased access and deployment of these systems. And with this expansion in access, there has an increase in the risk, not only when it comes to population affectation, but also in the risks that this presents to society and the judicial system in particular. We will be discussing the case of generative AI within judicial decision making here, which has a tremendous potential to enhance this particular sector. There's potential for help with legal research, document creation, and when there's simply no sufficient hours to delve as deep as it would be necessary into precedents or different statutes or regulations or laws, that is something that generative AI can certainly help with. There's a lot of promise in that. However, the lack of safeguards or the introduction of generative AI also creates several risks, which we will discuss at a later point in this presentation. Next slide, please. So as I was mentioning, there's tremendous promise with generative AI integration within judicial decision making. There's a promise for increased efficiency. Generative AI can analyze a plethora of documents simultaneously and synthesize or analyze them, at least at a linguistic level. It could improve judgments, potentially making legal analysis more comprehensive, giving it more depth and more breadth. And then it also holds promise when it comes to certainty and jurisprudential consistency. Meaning, there is a potential for increased clarity. This would allow for precedents to really be consistent with each other and for legal reasoning to follow the same trajectory, whereas different judges could apply the law differently, including such a unifying method from the nature of the algorithm would allow for a lot of certainty. So these are the three main promises that we will be discussing today, and that we think are embedded within the introduction of generative AI into judicial decision making. Next slide, please.
So as David was mentioning before, of course, we all have heard about the promises of generative AI, and the scholarship has been trying to explore those promises, and we try to lend that scholarship into the context of the judicial decision making. But at the same time, we are also aware that that potential can't be realized if we don't manage and mitigate the risks. So we also try to map in this paper the risks of using generative AI in the courtroom, particularly to inform decision-making processes. So based on past scholarship and what we have seen in some case studies, we have identified 7 risks. Some of them are part of the traditional scholarship of artificial intelligence, something that we have been discussing for a couple of years already, in terms of the governance challenges and other risks in the use of AI. But with the entrance of generative AI, we are seeing new risks as well, or the exacerbation of some of those traditional risks of predictive AI. So let me tell you some of those risks that we have identified. Transparency, public trust, and acceptance. So we know that machine learning is the base of the technology that these generative AI algorithms and LLMs use for operation. So when we talk about machine learning, we refer to the traditional scholarship in predictive AI of the problems of transparency, explainability, and the general problem of the black box algorithms. In this sense, what we mean is that we see that's traditional risk, but what we have seen in and what the scholarship has been trying to explain in the past months, almost 1 year already, is that generative AI may exacerbate this problem of transparency and explainability due to the way of these models operate, not only because they use machine learning techniques, but also because of the way of these amounts of data that they need in order to process and to produce the outcomes. So this may erode in the context of decision-making processes in the judicial system, public trust and acceptance to this type of judgments that are based on the use of generative AI. Other examples of these traditional risks that are exacerbated are fairness, bias, amplification, and that has a consequence in terms of precedent interpretation. Also, data quality is a challenge of predictive AI, but it's even more important when we think about the context of LLMs or generative AI. Why is this? Because data quality may end up not only in false outcomes or a prediction that is not that accurate, but in the context of generative AI, we talk about the term of hallucinations. So this false information can be produced in the outcome as a fact, and that could have important consequences in the context of judicial decision-making. We have heard about these infamous cases of lawyers, for example, in the legal practice, using generative AI platforms or models to inform themselves and to produce documents for filings. Those documents have been including false citations, for instance, or cases that don't exist. In other context, cases that are not relevant for the case that the lawyer is advocating for. So there are some ethical and legal issues around this problem of hallucinations that could have greater consequences in the context of judicial decision-making. Imagine if we're not talking about a lawyer, but a judge that is facing these type of problems of hallucinations. Other risks that we have identified are related to accountability and legal liability, given that, of course, the judge will be the responsible one for producing the decision. But at the same time, what would happen with the chain of accountability and liability because of the different stakeholders that need to interact in order to produce an outcome when judges use generative AI? Are we going to treat these cases as a case of product liability or as another type of case? So this is something that has been discussed in some jurisdictions, for example, in the European Union currently, with the proposal of liability in the context of artificial intelligence with the directive to treat these type of models as products, but that's not something that has arrived to the level of judicial decision-making. And of course, it's a debate that other jurisdictions have not even started yet. Data protection challenges, it's something that is present in the data economy in the world in which we use AI to automate many processes. But in the context of generative AI systems require massive amounts of data. So when these models even feed themselves with outputs that they produce or that were integrated in the model by, in this case, the judge, we need to check what is going to happen with that data if that is classified as personal data. What are the balances that we will need to implement in order to check that we are not violating data protection regulations? So are judges ready to deal with these type of challenges in terms of compliance? So that's something that we also need to discuss. And finally, judicial independence and access to justice are two of the risks that we have identified in the use of generative AI in the courtroom. So we capture different use cases, different case studies that of jurisdictions that were in which judges have been using the technology. Colombia, Peru, Mexico, and India. Interestingly, all of them are countries that are part of the same type of approach, a jurisdiction in which we haven't seen yet a regulation applicable to artificial intelligence, and also there is no strategy, at least in a coordinated way and at a national level, in order to guide judges in the use of this type of technology to exploit the benefits or the potential benefits of the technology. Let alone, there's nothing yet in terms of how to mitigate the risks of the use of the technology. In Colombia, for example, one judge tried to use he disclosed that he was using ChatGPT to inform himself about some legal norms in terms of medical coverage in one specific case. As I said, all these jurisdictions are part of the same type of approach. This model, we name this model under the unregulated approach term. So that's why you see here in the table, in the last row, Colombia, Peru, Mexico, and India, the case studies that encourage us to explore more about this topic of the use of generative AI in the courtroom. But what are the other approaches, and do they exist currently? Yes, they do. So we have seen other jurisdictions in which judges have not used, or at least they have not disclosed that they have been using generative AI to inform themselves when they produce a decision in the judicial context. But there are some guidelines or some regulations or any type of policy that is guiding the use of the technology in different ways. So what are those approaches? The targeted approach, which is implemented by the UK, New Zealand, and Australia, are those jurisdictions are part of an approach that mandates something in terms of the use of generative AI. The general mandate here is, for example, some limitations in terms of when judges can use generative AI. Some jurisdictions, for example, New Zealand, go beyond that, just imposing some limitations to say we are not ready yet because we need to think about and make an assessment on how to mitigate the risks of using generative AI. So before doing that assessment, we are not ready to allow judges to use the technology, even though we know the benefits, the potential benefits of using generative AI. So that's a targeted approach. Those jurisdictions that have said something about the use of generative AI. Other jurisdictions have said that they will be implementing a guidelines-based approach. That is the case of the European Union. So there is no specific mandate that can be enforced on judges, but on the European level, there are some guidelines to let the judges know about the risks and potential benefits of the use of generative AI. But there is no authority that can enforce these type of guidelines. The deployment of generative AI, it's another approach. This one is very interesting because these jurisdictions are the ones that are developing their own model internally. So we often know these models of generative AI and LLMs as open source models that are available for free to the general public. These ones are also based on other open source models, but will be used internally and feed internally with internal databases for the judges in those jurisdictions. Those are Singapore and Estonia. Those are two jurisdictions developing their own generative AI model for courts to use. And the deterrent approach, those jurisdictions that have said we are not yet allowing the use of generative AI, and judges should avoid the use of Gen AI in the courtroom. That is the case of Canada. Though that is the map of the world in terms of how jurisdictions have approached the use of generative AI in the context of judicial decision making.
Fantastic. Thank you, Nydia, for such a wonderful presentation. Now I will proceed to explain some of the risk mitigation strategies that we're proposing on this article. So as Nydia very eloquently established, there's been several cases in which generative AI has already been introduced into judicial decision making. Judges are already openly discussing the utilization of generative AI. In fact, the 4 jurisdictions that Nydia mentioned, being Colombia, Peru, India, and Mexico, all utilize ChatGPT. Now, there is an elevated and heightened risk inherent to the legal profession. So when we're discussing the implementation of generative AI into the courtroom, this triggers the necessity to safeguard a plethora of different rights and privileges of those who access the judicial system. And Nydia and I have developed risk mitigation strategies to ensure that when generative AI technologies are introduced into judicial decision making, they enhance the productivity and promises that we were discussing earlier, at the same time mitigating some of the risks. So we have divided our risk mitigation strategies into 2 major categories. The first one being foundational standards, and the second one being application principles. So the foundational standards will be an ex ante group of recommendations targeted at creating a set of foundations prior to the introduction of generative AI into the courtroom. Whereas application principles are are to be deployed, are to be established and utilized once the generative AIs are already in the system as ways in which to mitigate the active development and deployment of these technologies. So when it comes to foundational standards, we start with capacity assessment. So jurisdictions should evaluate their infrastructure, expertise, and resources before implementing generative AI. This means prior to the integration of generative AI, we have to assess where a jurisdiction's capabilities are, and then we can proceed with the rest of our foundational standards. The second one would be stakeholder engagement. So we should engage judges, lawyers, court staff, litigants, developers, and the public to increase diverse perspectives and enhance the systems of trust that provide the foundations to our legal systems. So the more that we integrate the different parties that we are looking to engage, the more legitimacy and substantiation these processes can have. The third one, our third proposal is licensing and verification. So we should establish a licensing regime we propose to establish a licensing regime to ensure that generative AI systems meet quality, fairness, and ethical standards, amongst other standards, before they're used in courts. So prior to the integration, there should be a checklist of different foundational and crucial items that the generative AI systems should meet in order to be able to be integrated. This would also provide a lot of certainty for developers, as it would reduce the risk and increase regulatory certainty. The fourth proposal of our article is to establish trusted datasets and explainability. So we advocate for the use of high quality, unbiased datasets and that ensure that generative AI decision-making process are both explainable and transparent. So we have seen the utilization of ChatGPT in the 4 cases that we've discussed, right? So this is an open source network. It's an open network in which utilizes a lot of data that is extra legal, that is not directly cases, not directly based in cases, and not directly based on specific laws or targeted regulations. And we have also seen that through the application of this particular technology, there's no explainability or no transparency as to how the model arrives at this question. So our foundational standard here of trusted data system explainability seeks to diminish the risk of different data sets that may not be legal in nature or that may lead to inaccurate results, and to ensure that the individuals who are affected by by a specific judicial decision are capable of seeing why the decision was made, and under which conditions and regulations or precedents. The latter of our foundational standards is allocation of responsibility. So here we are advocating to develop clear frameworks to allocate responsibility between developers and judges to both encourage innovation and maintain judicial integrity. This concludes our foundational standards, and now we'll move on to our application principles. So within the context of our application principles, our first proposal is to update ethical standards and enhance continuous legal education. In essence, our proposal establishes the need to enhance and adapt the ethical standards of our profession, of our legal profession, and mandate legal education on generative AI for judges and lawyers, so that they may be aware and capable of managing these new developments. Basically, allowing judges and lawyers and all of those involved in the legal profession to be able to have a tool set that allows them to understand and manage this new emerging technology. Another of our proposals would be is related to prompt engineering and the judicial decision system. So we want to ensure detailed and context-rich prompts and ensure that they are used in a targeted way for consistency and to protect privacy rights, which we will discuss further in just a second. So our third proposal will be case-based risk assessment. So we want to ensure that we implement a risk-based framework to determine the level of generative AI involvement and review required for different cases. So not all cases in the judicial system are created equal, and they all have different risk profiles. What we are advocating for is to establish a system that determines what the risk is based on the case, and then heightens the level of scrutiny necessary, the requirements necessary for the involvement, were it to be partial or complete, of generative AI into the judicial decision-making process. Moving on to disclosure to the parties, what we're advocating for is that there's mandatory disclosure of generative AI use to all relevant parties to ensure fairness and build trust. This empowers the different parties to know where generative AI is being used in their cases and what the application parameters will be. Will it be just used for proof? Will it be used to establish the severity of mitigating or attenuating circumstances in their case? Or will it be used to generate sentencing or aid in judicial decision making? All of these things are items that should be disclosed to the parties. Moving on to verification system, we want to establish a verification network tailored to the risk level of the case to review and then validate the generative AI outputs. So when we establish a prompt and we ask a generative AI system to perform a specific task within the judicial context, it will provide us with a response depending on the risk profile of this response, whether it intrudes upon the monetary freedom of the user of the legal system, or their physical freedom of movement or incarceration, it will require different verification levels or standards of review necessary from the judicial office holder as that is in charge of this particular case, and there should be a specific review according to the risk. When it comes to specific procedural rights, in terms of scope, consent, and escalation procedures, what we were advocating for in our proposal includes providing parties with the right to opt out. It's basically what we're trying to do in essence is establish targeted procedural rights that are specific to the involvement of generative AI in judicial decision making. We're to be providing parties with the right to opt out or modify the scope or application of generative AI, ensuring transparency of the utilization of the technology, as well as establishing, for example, appeal rights for the redress of either generative AI outcomes or the utilization in minor components of a judicial process. Lastly, when it comes to ongoing audits and evaluations, we are advocating for a continuous iterative audit system that seeks to ensure compliance with ethical and legal standards in an evolving manner. So once the generative AI specifics the generative AI systems are accepted and involved and embraced by a specific judicial decision system, that's not where the licensing or verification fully ends. We believe that there is a need for a continuous and evolving iterative process that ensures the technologies and specific rights protections continue throughout the lifetime of the involvement of generative AI in decision making.
With this, we close this presentation, and we hope these highlights will encourage you to check the paper. We described in much more detail each one of the risk mitigation strategies, the case studies that inspire us to think about these strategies, and also the regulatory models that map the world of responses to the use of generative AI in court decisions.